So welcome everyone to the Presentation Guild for this live webinar called Making Sense of Legalese. Today we have Charlie Meyer, a partner at Woodard, Emart, Moriarty, McNett, and Henry LLP based in Indianapolis, Indiana. Charlie is chairman of the Trademark Practice Group. As a prosecutor and litigator, Charlie represents and counsels clients in various aspects of patent, trademark, copyright law, including search and prosecuting patent applications, clearing and registering trademarks, copyrights, licensing, enforcing, and defending intellectual property rights both in the U.S. and internationally. He joined the legal firm in 1995, made partner in 2001, and is sharing his knowledge of the legal landscape specifically as it relates to independent graphic designers looking at contracts for their projects. On a side note, Charlie has worked with Echo Swinford and also myself on a joint project I worked on with Echo for many presentation clients specific to our industry. So we are getting great information from somebody that understands many of our specific industry needs. Very excited about this morning and the information that's going to be relayed. In addition, we have Echo Swinford of Echo's Voice, a presentation designer and president of the Presentation Guild, running everything technical about the webinar, and myself, Troy Collar from TLC Creative Services, Inc., being the host of this webinar. Charlie, please take it away.
Okay, well, thank you, Troy, and appreciate the introduction there. Good morning, everybody. I'm glad to be here, and I do look forward to your questions and happy to provide some answers to the extent I can. I wanted to give us some ideas of what's going on and talk about legalese. I'm not going to try to say that contracts are the most exciting topic for everybody to talk about, but there's something we have to deal with, and it's something that it is important for you to understand what's going on. I'm also not going to try to do this on a word-by-word basis for discussing what is the language in a legal contract. But I thought I'd approach it from the anatomy standpoint to give you an understanding of what we're trying to do in the different parts of the contract and what's the point of why we're doing this. I'm going to start at the very beginning. In Contract 101, basic law school, what do we start with? Is a contract is offer plus acceptance. And that's basically one person is offering to do something and the other person is accepting their offer to do that. Now, that also requires consideration, and that means usually payment or some other transfer of value, because gifts don't count as contracts. So let's look at a contract from the offer and acceptance standpoint. Now, what you'll often see and what you're usually familiar with is the formal contract or the written contract, and that's what I'm going to spend most of my time talking about today and what we're going to work through. But keep in mind, contracts don't have to be in writing to be binding. You can have verbal contracts, just over the phone or a handshake deal, or even an informal contract, which could be, again, over the phone, handshake, by email, etc. Those are still binding as long as there's an offer and acceptance. The problem is when you have an informal contract or a formal contract that is not as complete, you may wind up with loopholes or openings when some circumstance comes up that the parties were not expecting or didn't plan to deal with in advance. That's where the default rules come in. That if the parties haven't dealt with the situation, there are rules in the law where the court, if it comes to a dispute, will try to interpret what the parties would have agreed to and fill in the blanks. Now, it's a lot better to have those blanks not there in the first place. So that's our goal in writing the contract. But if necessary, then the court can fill in the blanks with some of the default terms. And quite honestly, in an ideal world, if everybody agreed and everybody understood, would you need a contract? Probably not. I mean, the contract is there for the situations where there is a potential for misunderstanding. So if something comes up later, the parties can go back and say, okay, here's what we agreed to, here's what we thought we were agreeing to, and just the whole idea here is to prevent the miscommunications and have that communication up front. And now I've talked about, written contracts are going to be on usually a formal contract you might see. Verbal contracts are different. Something that comes up often in a twist here is the NDA or non-disclosure agreement. That is also a contract, but some people try to rely on that as the overall contract. That's not really a contract for services or performance of doing something. An NDA is usually more of a preliminary threshold agreement where the parties are agreeing to keep information confidential. So if you're asking as we go along, is an NDA enough? Usually it's not. That's usually just a starting point, and usually the purpose of that is to get the parties into discussion where they can share information so they can develop the full-blown contract. Now, as you go through the contract, this may seem obvious, but the first thing you want to have at the top of the agreement is a title. Now, there are various types of titles, and I tend to try to avoid one that's so boring as saying just agreement. Let's talk about why we're here. Is this a graphic design contract? Is this a license agreement? Is this a settlement agreement? This is a signal that's setting the stage for why you're here. And then sometime later, if you're using it in an index or you need to refer to it, referring to the design contract or referring to the settlement agreement gives you a clue of what you're talking about. So that's really one of the opening parts when you get into drafting the contract. And then right after that, and you'll see this in most contracts, is who are we? That's where you list out the parties that are involved and start saying, sometimes contact information, but the interesting part there is to make sure you specify the entity type, because that does make a difference later on. Who are the people involved? If you are the person who's individually as a party, that makes you personally responsible for performing the services or providing the payment or whatever your obligations are. If your company is the entity, that makes the company responsible, and the services or payment can be provided by the company, which may mean you personally, it may mean your employees, it may mean subcontractors, it may even be a successor if you sell the company. And that's a difference that makes a difference on who are the parties to the agreement, and then where you're going from here. Now, this is sort of the very, very beginning to put in the title and identify who the parties are. As we go through this, a guiding principle is who has the bargaining leverage. Because I can go through here and say a lot of what is ideal and what is desirable, but when you get into a reality check, some of these things depend on who's willing to agree to what, and who's willing to walk away, or who's willing to draw the line of what can or cannot be done, or what they're willing to agree to or not. So even though a lot of these terms may be desirable or ideal in certain situations, you just have to realize you're not always going to get what is as in your favor or as ideal as you would want. Now, after identifying the parties, usually we have some whereas clauses. Now, you might think that's, old school Latin, and the whereas probably is. But the purpose of this is we're setting the context. And it's saying, why are we here? I'm an expert in graphic design. You want graphic design services. I'm an expert in this, or we have a claim about that. We're willing to settle the claim. This is sort of giving the idea of why the parties are here and where you're going, what sort of cluing you in to what you're providing and what you're bringing to the table. Now, importantly, you don't want to go into too much detail in the whereas clauses. In some agreements, those are considered incorporated into the terms of the agreement, while in other agreements, those are not considered part of the actual terms. But the more substantive you make them, the more you risk having them be incorporated, and then can they be used against you? If you say you're an expert in something, and they may say, is that a warranty that you're an expert? Or are you saying that you are special training? Whereas if you just say, I'm willing to provide certain types of services, that's a little more generic and it's clear. without being a binding, something that can be tested or be subject to dispute later on. So I like to put some things in as whereas clauses, but I really like to make them non-binding, really sort of vague at a general level. Now this is sort of just the beginning, setting up the stage here, and I set a position for some questions and answers. It may be early, those haven't developed yet, but I wanted to give people an opportunity.
Well, Charlie, if you're okay, I got a few questions that came in. I'd like to kind of hopefully put them in a logical order here, and anybody else can feel free to use that Q&A panel. So the first question was going back to the concept of the NDA, and to confirm, can you first define NDA, because that's an acronym. I want to make sure everybody has the understanding of what that is.
Sure, we're usually referring to a non-disclosure agreement.
Great, or confidentiality agreement is another term for that, correct?
Purpose of a confidentiality.
And the second question is, oh, sorry about that. Now, the second question that also related to NDA is a little more, it's a great question. Is the sole proprietor the contracted party, are they the company or the owner? So when you're a sole proprietor, how are you going to define yourself on a contract or an agreement?
That's a great question. Now, legally, a sole proprietor and the company are the same entity. And that's the difference between a sole proprietorship versus a partnership or versus a corporation or an LLC, some type of incorporated company. From a sole proprietorship perspective, the individual can use a DBA, which is basically the nickname or doing business as, for the name of their operations. But legally, that is still their personal name. It's just used as a nickname if you're using a company type name. To really get the benefit of the legal distinction, you need to have an incorporated business or an incorporated LLC organized as a business.
Great. And one more, because I just read those out of order. The second part of the NDA one, that was actually a totally separate topic there, is can you confirm that a non-disclosure agreement, NDA, can it be a separate agreement, or is it part of a contract, or can it be either?
That's another good question. It can be either. The typical approach, or often where these come up in an NDA situation, is sort of a threshold or just the beginning of discussions when the parties are exploring whether they want to get into a full-blown contract arrangement. And so you might say, for the purpose of exploring a business relationship, we're willing to share some confidential information, which may be pricing, it may be just what the project is in the first place. And then the parties agree to that on a preliminary basis. Once that's in place, the parties are free to communicate about what they're planning to do. And then once they come up with what they're planning to do, we memorialize that in a more formal contract. Often the confidentiality provisions in the formal contract replace the confidentiality provisions in the NDA. So to that extent, it can be either one. As another approach, if you don't have any confidential information you need to share before you enter the contract, you can just embed the confidentiality provisions into the contract because you don't need them until you get into actually doing the services.
Wow, thank you for clarifying. I'm going to turn off my webcam and let you go through the next segment. I'll look for the next Q&A segment. Thank you.
Okay, sounds good. Well, we've gotten past sort of the beginning, just setting up the page 1 of the contract. Let's get into the substance. And really, what am I doing? If you think about a sentence, this is the verb in the sentence. The beginning part was just the noun of who am I and why am I here. But the verb is what am I doing? This is the list of activities, the services that are going to be provided, where this is really the substance and the first thing that you guys are really interested in as far as it's going to change in every single contract. And this is where you say, I'm going to provide certain services, or we're agreeing to settle certain things, or provide certain programming. If it's a goods contract, it'd be I'm going to sell widgets to you, that type of thing. That is going to be spelled out, and there are various ways to spell it out. If this is sort of a one-time contract, or it can be spelled out relatively compactly. Often we'll just explain that in the body of the contract and say, I'm going to sell you widgets, or I'm going to provide you certain types of services, and here's what it is. Sometimes that can get confusing if that's a really long schedule of work, or if it's a long, detailed list of what's going to happen. And in that case, the way we often set it up is to say, I agree to provide the services in Exhibit A, and then you put your statement of work in Exhibit A. And that can be the detailed landmarks, services, whatever you're going to spell out of what you're going to provide and how long you're going to do it, all of those types of things. And that's where we can put in a cross-reference or use that as an exhibit. One of the advantages to that approach is that the body of the contract can often be used as a template, and then just you replace the statement of work each time you do a new contract. That can be very helpful, and we don't have to draft a contract from scratch each time. Now, another way to do this, which is somewhat of a variant on this, is if we agree to a master agreement. And that's generally more appropriate in what you hope to be a long-term relationship, where the parties say, we hope to do multiple projects together or work together on a long-term basis, but the statements of work may change. There may be multiple statements of work. So what we're going to do is agree to a master or an umbrella agreement where the parties have agreed to certain terms that are going to be in common for each project or each arrangement. So you lock those in, and then you go back and say, okay, we're going to have the statement of work or multiple statements of work. You set it up, they're going to be each one. And each of those has to have its own offer and acceptance to become part of this contract. And that can have different services, different payment plans, whatever is involved. But it saves the parties from going back and doing the, in one level, the boilerplate type statements when they're just doing projects over and over again. Now, going back to the entity type, that's something I mentioned earlier. One of the things you want to spell out in your statement of work is who is going to be doing the work. If you are a sole proprietor or an individual who has signed this, the expectation is, again, the default term, that you're going to be the primary individual personally providing the services of what you're agreeing to do here. Differently, if the company, like an incorporated company, has agreed to do the work, the default is that anybody in the company can do that unless the parties have agreed otherwise. And so if you want more flexibility to have subcontractors, employees, that type of thing, you might want to have a company incorporated up front. But again, we've also had situations where the purchasers want to make sure they know exactly who's doing the work, and it does make a difference to them if there are employees or subcontractors, and if they're in the U.S. or not comes up sometimes. So it's really a nice point to spell it out here. Again, you're avoiding miscommunication, so everybody knows who's doing what and when. Now, something we want to often consider after the initial discussion of what is a statement of work is make sure you have thought through the details. If you have agreed to provide graphic design services for a certain project, what's going to happen? How is that project going to be delivered? You know, it's one thing to just do the substance and the basic content that you're delivering. But once you deliver it, are you going to be providing training? Are you going to be providing support? What if they want changes? Do they want modifications? That's something that's very helpful to spell out in the statement of work, because they may think training and support is included in the basic price, and you're just focusing on the time to develop the basic content. So again, it's about avoiding miscommunication and talking about what are the details here. Now, something that comes up related to that is the timeline. That's often good to put in your statement of work. Sometimes it's necessary to put in a calendar date for when something will be done, but something that I prefer, if it's possible, to put in what basically is a formula approach to the timeline, because things are going to come up that you don't expect. And what we'll say is, okay, once we have agreement on the basic contract for phase 1, it will be delivered in 4 weeks, and then the purchaser has, say, 1 week, or it's expected to take 1 week to approve that or review it. Then you say, okay, phase 2 starts when and only when the purchaser has approved phase 1. So that is not a date that's fixed in stone. That's a date that can change. But once that date starts, phase 2 may be another 2 weeks. And then you repeat the process, setting it up as a formula. And that builds in flexibility into your schedule and your timeline. On the flip side, if you have specific calendar dates in your timeline and something takes longer than expected, you have the domino effect of things can get out of schedule, and then you have to go back and do we rewrite it? Do we write an addendum? There can be a disconnect between what the contract says and what's actually happening at that point, and it's easier to try to avoid that. Somewhat related to that is if you need extra hand-holding, or more precisely, the purchaser needs extra hand-holding, and that's back in the training, support, modification, or just kicking them into giving you an acceptance. That's something that you want to build into your discussion of your statement of work and what your expectations are. Now, on the flip side of that, something that we want to make sure we have considered in drafting the statement of work is, what are you going to need from the purchaser or the client in order to be able to do your job? I mean, cooperation seems obvious, but we've all had the client who you send an email, say, hey, I need a response, and then you wait, and then you send a reminder, and then you wait some more, and that can throw off the whole process. So make sure you spell out to the client what you need, what responses you need, and then more substantively, or when you're getting into the substance, do you need access to their systems? Do you need access to their confidential information? Do you need access to know their operating system or the software version they're using? There may be information you need to plug into your services so you can make sure what you're delivering actually operates with what they are doing. So that's something we definitely recommend that you spell out in the statement of work. Now, once you have agreed on the statement of work, hopefully everybody's moving on their way, but then how long am I here? In many cases, contracts will expire on their own terms or lapse because you've completed the project. That's obviously what everybody desires. Everything goes well, the contract has been completed, and everybody's happy. But what if it changes? I mean, the first option is, what if you have buyer's remorse, or seller has a change of circumstances that you want to get out of the contract, or one party wants to get out of the contract, even though there hasn't been a breach. So you may want to put in some cancellation options that say, okay, you can terminate at any time, or terminate at certain points, and then I'll get to consequences of that. But you might want to spell out, if one party has that power or that option, to give them that flexibility. On the flip side, and we hope this doesn't occur, it's if a breach occurs in the contract. Now, something we will often put in is require a material breach, which means it really has to be an important breach, not that an I didn't get dotted or a T crossed somewhere in there. And the standard approach here is to say, okay, if there is a material breach, the person who thinks that that has happened has to give notice to the other side, and generally we like an opportunity to cure, that side has the ability to go in and fix it if possible. A standard approach here is to say, okay, you've got notice of breach, 30 days to cure. One of the things I recommend and I like to put in there is a due diligence approach is sufficient for cure. Some problems can't be cured in 30 days, especially if you're taking some of those days to figure out if there is a problem, or if there's disagreement on if there's a problem, or figuring out how you're going to approach it. So I recommend, if possible, that you put in something that 30 days to cure, and or begin due diligent efforts to cure. So that's a practice tip I'd suggest when you're looking at these types of notice of breach type clauses. Now, consequences. There are going to be consequences if the contract terminates early. That's just part of what goes on here, because not everybody got what they paid for or what they expected. Generally, contract breaches, terminations, don't get you into the punitive damages or the emotional distress type of damages. You're really looking at the value of what has been delivered versus what has been expected. For example, if we have cancellation without a breach partway through the project, we might want to set up a pro rata formula that the designer gets paid for time spent, at least until the notice of termination. And so you can put that in as an hourly rate, you can put that in as a percentage or a non-refundable deposit. There are a couple ways to do that. But you want to set up something that says, okay, if you want to get out, we'll give you that flexibility, but you don't get out, as if this never occurred. You deserve to be paid for time you spend and services you render, even if they decide they don't want to go all the way through the project. Okay, I think I've reached the next point and see what's come up as questions now.
Thank you very much, Charlie. This is a lot of information, that is for sure. Let me see if I can define or pull a couple of these down. To clarify, a statement of work is a contract, but it can be separate from the main contract. So we could have a master service agreement and then smaller statement of works for defining small projects, correct?
That is correct. Now, you have to go back to your basic offer and acceptance, because it's sort of two contracts that integrate to form a contract. Because your master agreement or your basic terms are offer and acceptance of certain things, but your statement of work is integrated exhibit to that, because that's part of what you're offering and accepting, at least on that particular statement of work.
And then to follow up with that, the idea of early termination is definitely a hard topic for freelance designers to implement. So in most of the contracts I've put together, if we have a master service agreement, the early termination clause or information is defined there, but a statement of work could be the element that we have to early terminate. So I'm trying to think how to put this together into a single statement based on a couple of people's input. So one presenter noted that a willingness to walk away is kind of a good mindset at the beginning when you're looking at a contract. So in other words, you're going to put out early terminations that you're willing to walk away with. It's kind of a starting mindset. Is that does that kind of go with how you're working with your clients often in defining what an early termination is?
That's sort of it. The early termination or being willing to walk away is often a negotiation tactic in the overall who has the bargaining.
Okay, correct.
But the statement of work is being willing to walk away is more of a willingness to stop, not necessarily to walk away as if it never occurred in the first place. I take it more that, okay, I'm happy to work with you. We're going along. Everything seems to be going well. If you change your mind, I'm willing to stop and walk away at that point. But, and here's the flip side, I should be paid something for what I have done to this point. Sometimes there are landmarks that we'll put in as far as a project that phase 1 has this, phase 2 has that, and then you can do a pro rata amount of the overall payment scheme that, after phase 1 I get this much, after phase 2 I get this much, or if I'm partway through phase 3, depending on hours I spent or percentage, and it takes some documentation on that sometimes, I'll get a percentage of phase 3. but then I'm willing to walk away.
And those phases are directly pulled from the timeline definition that we talked about earlier.
Exactly.
Generally?
I mean, and not every project has that type of timeline that makes sense. But usually you can say the project's going to require so much effort. You know, I have an estimate of it's going to take so many hours, or it's going to take so much time, or whatever that effort can be. And then you try to measure what the effort is, and then a relative value to the whole.
Perfect. Okay, two more before I let you go through that next section there. One is a clarification. We have some international attendees that may have different legal terms. Mm-hmm. So I think the key here is to just reiterate or confirm that you are a U.S.-based legal firm, correct? And so anything that's international needs to be applied locally.
Definitely. I would not claim to be a contract expert in foreign countries, but I will say generally the basic approach is common.
Great. And let me know if this one's going to derail us too much, but it's a great question. It's more, we've had a few questions around the structure of a business. So this is slightly off topic, but it does relate to the contract. So basically we have sole proprietor, we have LLCs, we have different corporate entities. They're all business structures, correct?
Correct.
Okay. And a contract will apply to any of the business structures, correct?
Correct. I mean, legally, a business entity is equivalent to a person. Now, you can debate the philosophy of that, but the entity can be considered a party as a single party, even though it's built up of a number of different people or subparts.
Okay, and while we don't want to get into defining which is the best business structure for anybody, this is how it relates. How do we define our business structure in a contract? I mean, we need to call out the fact that we are an S Corp, a C Corp, or sole proprietor somewhere in the contract, correct?
Not really. I mean, you at least not at that level of detail. You want to say what type of entity you are, as in if you're a corporation. You don't have to say whether you're an S Corp or a C Corp. You don't even have to. The default, if you just use your personal name, is that you're a sole proprietor. So you don't have to call that out. Some people do, but that's an excess. It's not necessary. But what you want to do is say that if you're an Inc. or an LLC or some sort of corporate type of entity, you do want that mentioned in the contract, preferably back in the introduction.
Perfect. Thank you. I know that was a little bit off topic, but I think it definitely relates to many of us listening in. Okay, I'm going to turn you loose to kind of go through our next segment, and I'll pop back in when we have more Q&A.
Okay, sounds good. Well, we've been through the statement of work and how you set up the verb in the sentence, but show me the money. That's the other important part of a contract. And that's the consideration aspect that everybody is very interested, of course. What you want to have is obviously a payment obligation spelled out in the contract. Now, how this is spelled out can depend on the structure of how you put together the statement of work or the master agreement, or whether you put the obligations of those services in the basic text of the document. If you have the basic obligations in the text, then usually we will correspondingly put the payment obligations in the text, just as an embedded description. The other approach is to have the payment obligations also be specified in the statement of work. And that way, if you said, okay, here is a sub-project or a standalone project, you put in the payment consideration, or what's going to be paid for that, in that subcontract, and you're agreeing on that each time as a separate component. Now, you can put in some of the audit and payment terms, but the basic, am I going to be paid hourly? Is this going to be a fixed fee? Is this going to be paid in portions based on phases? You spell out in the basic payment obligation there or in the statement of work. Now, something you want to make sure is in there is not necessarily payment in the sense of what you're getting paid for your time and services, but costs. And those are generally more of the physical or intangible costs that are associated with providing what you're doing. For example, if you are relying on software that's being embedded, do you have to pay for a license for that software? If you are traveling, do you need travel expenses or meal expenses? These aren't necessarily the payment obligations in a legal sense, but they're payment that you want to have it spelled out and, again, avoid miscommunications on how are those costs going to be covered. Some people, some clients will expect those to just be a cost of doing business that you're supposed to absorb, and others will understand that those are, separate and above and beyond. So spelling those out in parallel with the payment obligations avoids, again, the miscommunication. Well, one person thinks it's incorporated and the other person thinks it's separate. Now, going back to consideration, value being delivered for a contract does not have to be monetary payment. So keep in mind there are situations where you want to get consideration in other forms. That can be recognition, advertising, attribution. Now, attribution is where it says this is provided courtesy of, or provided from, by, or sponsored by, basically where you get credit as a named credit for doing something. And there can be value to that. And if you want those to be part of the contract, then you should spell them out here. There's an interesting rule in copyright law that an artist does have the right of attribution to artistic works. And that does apply to what we're doing here. Usually that is more of a famous painting. The artist wants to have his name, remain associated with the painting. But you could have something where you are providing a design or a content presentation where you want credit as saying, hey, this was provided or prepared by such and such a person. And so you want to spell that out. Which is a great segue into who owns what. And since I'm an intellectual property attorney, this is what I do a lot of time on in agreements. But to get to a starting point, in intellectual property law, there are three basic theories of types of intellectual property. You've got the copyright, which is generally what you guys are going to be dealing with, and that is protection on expressions, anything that's fixed. It can be artwork, photographs, text, screen layout, music, all of those types of things. Then you've got your patent area of protection. Generally that's on your widgets or on your laboratory processes or manufacturing processes, not necessarily as relevant to what you're doing on a day-to-day basis. But you need to understand the difference here, because the patent can go toward protecting the idea, whereas the copyright protects the expression and doesn't protect the idea. Now the third category of intellectual property, which you'll see, is branding or trademark. And that's all about identifying a single source for particular goods or services. That most commonly is a name, which is going to be a word. It can also be a logo. It can also be a recognized look and feel, which can be a trade dress. Like you see the golden arches, and you know that's McDonald's. Or you see the profile of a soda bottle, and you know that's Coca-Cola, even without seeing the name or the logo. And that can be very important on how branding is set up and how clients might want their design project to appear. When you're looking at a trademark, you will often see a TM symbol. And that's because trademarks do not have to be registered in order to be protected. Those are called common law or unregistered trademarks. And what I recommend is put the TM symbol next to any trademark you're using, because you can use it for free and you can use it without having a registration. If it's something that you're using as a brand and you want to put people on notice that you're protecting, go ahead and use the TM symbol. Now you can upgrade to a federal registration, which gives you some extra legal benefits and nationwide rights, and that's when you get to use the Circle R. and Circle R stands for registered trademark. So there are benefits to that, and I'm happy to go into those later if somebody wants to. Now, when you're getting into who owns what, keep in mind the guiding principle here that everybody wants freedom to operate. You know, the purchaser wants to use what they paid for, and the supplier wants to keep supplying. That's their work, that's what they need to be able to do. And the purchaser will, needs the ability to get what they paid for. Now, the purchaser may think that means they need ownership of everything, and that's not necessarily required. There are ways to get around that, and the supplier can't necessarily assign everything because then they can't use what they've assigned again. And that's what comes into why they need the freedom, is the reuse. And this will come in from both the purchaser and the supplier perspective. I mean, who can make copies of what was made? Who can make derivative works? Now, derivative works basically mean you start with a base work and then you change it. It may be some minor modifications, amendments, editorial revisions, or it can be a more major new work, although it's still recognizable as based on an underlying work. All of those are derivative works. And who can do that depends on who owns what and what permissions have been given. On the flip side, the supplier, who may be doing graphic design tools or tricks or even have some code or different macros that might do certain things, they want to reuse those. So the vendor or the supplier wants to make sure that they have that freedom to proceed. Now, what you want to make sure you understand here is that assignment is basically the sale of ownership in whatever is being assigned. That's in contrast to a license agreement. And a license agreement is a permission slip. That says that I own something, but I give you permission to do something with it. Now, the default situation, whenever someone pays for something, is that you have given them a license to at least use it for what the intended purpose was when they paid for it. That license can be broader, for example, allowing copies or derivative works, or it can be narrower. But that's part of what is good to spell out in the agreement here. The starting point from your perspective is that when you are an independent contractor, the law says if nobody has written something else into the agreement, the contractor is the default owner, and they have included an implied license at a minimum to the purchaser, that the purchaser gets to use that content for the intended purpose. But that's all the default condition says. What we often wind up doing in these situations is basically splitting the baby, because we want to maintain that freedom to operate for everybody involved. And so we look at what is being contributed into the project. And then we'll say, okay, what are we going to do with each component that has been contributed? There may be new material that's prepared by the graphic designer, or it may be pre-existing material. And is the pre-existing material supplied by the client, or is the pre-existing material supplied or reused by the designer? Those are things that can be split apart and treated separately. Now, when you're looking at custom materials, you may have incorporated the client-specific information into custom materials. That is sort of a gray area, that it mixes the two, and that's a little harder to deal with. But that can often be, at least conceptually, separated from material that's not specific to the client. For example, programming techniques or look and feel of certain things. What we typically do in this approach is do kind of a belt and suspenders and say, okay, I'm going to grant, as a graphic designer, I'm going to grant an assignment to the purchaser or the client for anything that is conceptually based on the client's specific information. Because the designer shouldn't need that again, and that's what the client arguably owned in the first place. But then, to the extent it's needed, I will also give a license to use any pre-existing information or new material that the designer has contributed to the project. And that license can often be unlimited to allow the purchaser to go do what they want to with that content. Again, we can put some limitations on that in appropriate circumstances. On the flip side, we spell it out that the graphic designer retains ownership of the non-client specific material and also retains the option to do whatever they want to do with it. And then, at least conceptually, this gives everybody the freedom to operate while spelling out ownership of who owns what, and then each party can go on their way. Slightly different point I wanted to bring up here is sometimes you say you're going to give content to the client and you'll never use it again. It is often helpful, if you want this option, to spell out and get permission to use a portion or some aspect of that client's project in your resume, or to be able to display something or at least mention something in your portfolio. So you might want to call that out as a specific exception, as something you have the remaining permission to do, even though you're not going to use all of the project. But that way you have something to refer to in the future. A bit of a variation on this, but it comes up in almost every contract, is the question of work for hire. Now, some people think work for hire is magic words, that if you say, I hired you to do something and therefore I own it, it really doesn't mean that from a legal meaning. Work for hire has a much, much more limited definition legally. And basically it means anything made by an employee is owned by the employer. But it doesn't apply to work for or independent contractor situations. Now, anything made by an employee of the independent contractor may be a work for hire for the independent contractor, but that's not a work for hire versus the ultimate client. So you'll see a lot of these situations, because this is very frequently misunderstood. You'll see a lot of these contracts will say, anything here will be considered a work for hire, but then they put the belt and suspenders on and say, but to the extent it's not, here's what we're going to do with it. So, understanding that that term is often misused, you'll still see it in there a lot. The more important aspect is what if it's not, or what is being done with the content. And it's easier to spell it out. Any content created hereunder will be treated as follows, and then spell out basically like the splitting the baby type of approach that I was discussing a couple minutes ago. Okay, we came to another question and answer, and hopefully I didn't confuse everybody too much there.
Well, there's definitely a lot of questions that came up, so let me see if I can summarize these down. And I don't want to take too much time away from your last segment, so I'm going to try and shorten these down and give you time, and if I have time, I'll get the rest in there. First question is, and there was a lot of questions around your copyright, patent, trademark segment, and obviously that's a big area for visual designers. But can you define a service mark?
Sure, that's a great question. Trademark is commonly misused or misused as an umbrella term. That's the common lingo. Technically, a trademark refers to goods, and a service mark refers to services. So if you have a widget, you can put a TM next to the name of the widget. If you are a service provider, you put an SM next to the service mark usage. But it's commonly misused. You'll see it all the time that people put TM next to service marks, just because a lot of people are not that precise. Circle R can apply to either one.
Okay, that's great. And the second one actually, I think, directly relates to that, is can a phrase be a trademark, or maybe that would be a service mark. So an actual statement about a company, maybe a company tagline, can that be marked?
Absolutely, absolutely. Often we'll call those slogans, or there are other ways to do that. Now you have to make sure it's not descriptive. It has to be an actual branding type of phrase. And there are some context rules that you want to treat it like a trademark or treat it like a service mark by setting it apart, capitalizing it, putting an SM or a TM next to it. But as long as you're using it to promote your services in a branding sense, a slogan can be a trademark.
Okay, I'm going to call this down just for timing because I don't want us to run out, but I do have this one question I think is a really applicable one, and it's an ownership question. So if a designer develops very customized handouts and presentations, so a training presentation that's going to be delivered to a specific client, so everything is branded under the client's name in order to make it applicable, who owns that content? Does the client automatically take ownership of those materials?
Well, that's the split interest there. You know, the client's original information that they contributed, their name, their layout, if that's what they wanted you to use, was theirs to begin with, so they keep it. And if it is client-specific information, you can agree to assign it to them, but the default condition would be that you would own whatever you created, at least whatever you contributed to the project.
Fantastic. Thank you. There are so many questions, but I'm going to turn it over to you to go through this last segment, and then with whatever time we have remaining, we will try and get through those. So please continue on. This is fantastic.
Okay, well, I'm happy to circle back, and I will try to keep everybody on time here. I know how important that is to everybody involved. So let's get into what people might often think is the boring boilerplate of, okay, we've just got some terms here. Do I really have to read all those? Do I really need them each time? We really do have a purpose for why they're in there. And again, if in an ideal world, you're never going to need them, but they're here for the situations where you don't have an ideal world. Clients especially, or often, will want a warranty. And think about what warranty makes sense, proportionally to the agreement that you're talking about. Is this warranty going to depend on the context as delivered? Is this warranty going to continue if the content is misused or modified or used for other purposes? Is any of this content dependent on the software or the operating system or the version? You might want to put some limitations on the warranty. I mean, the basic warranty everybody was going to want is it's going to work for its intended purpose. That's what everybody expects, and you really should be willing to provide that. But the question is then, once you go beyond that, where do you need, or what do they expect, and what's a reasonable expectation? How long is the warranty? Again, that's going to be proportional to the type of contract. Is it 30 days? Is it a year? Is it 10 days? Is this a one-use context? Is this a long-term context? And that goes back into pricing as well. And then what we often want to put in is a testing or acceptance period where the client will want the opportunity to test and make sure that it does what they expect it to. But you need to get that acceptance period closed. So what we put in as a default condition is an acceptance by silence, that you have maybe a week to test it, and if you don't bring anything up, that will be deemed acceptance, or 10 days, or whatever that term might be. Something else we want to also think about is no computer software, especially, or anything related to computers, is guaranteed to be 100% perfect. It's just not going to happen in most situations. So you might want to put in some language that it should be, work for its intended purposes within industry standards of acceptability. And what that means will depend again on context. If it's mission critical to the company, it's a different scenario than if it's just a presentation that's a one-time slideshow. And something else you might want to include is a cross warranty. that if the client is supplying you content or specifying certain things they want you to do, they're giving you a warranty that what you are doing is going to work, and they are not, and you're free to use whatever they're giving you. Which leads into the what if it all goes wrong scenario. Hopefully you never get to this situation, but if you do, fingers start getting pointed. So you start looking at indemnification. You know, clients often want indemnification that if what you provided doesn't work, or causes damage to their system, or infringes a third party, that you're going to be responsible for that. And to some extent that makes sense. But you also have to keep in mind the value of the contract and the proportionality of what they're requesting as far as indemnification to what is being provided. You know, if this is a small contract with a short-term deliverable, it may not make sense to put yourself on the hook for a patent infringement lawsuit that could be hundreds of thousands of dollars. But that is one of those, you got to get back to your reality check of who has the bargaining power on what comes in under indemnification. You'll also see insurance clauses in a lot of these contracts, and those are often the red flags. If you see them, you know the agreement was not actually written for this scenario. If you see product liability insurance requirements, those are usually for goods. You know, if you're selling widgets and there's some sort of product liability, not for services. That can come into play, but it's got to be more mission critical for those types of, for that to be applicable. If they have auto insurance, you know it's not relevant unless it's a very unusual situation here. In a lot of cases, the company will have in that they want to be listed as an additional insured. That can make sense, again, if it's mission critical software or something that is, you know, something very important, has major potential liability. For a lot of graphic design projects, that doesn't make sense, and you need to, or you want to push back and just explain to the other side that it doesn't make sense in this scenario. I'll try to keep going through here pretty quickly. There are a couple of different agreements you might see as far as non-compete. The non-compete basic one is that you agree you won't compete in providing the same goods and services as the company for a certain period of time in a certain territory. Usually that's not too big of a problem. The non-solicitation can go both ways, that you're not going to solicit their clients or their employees to work for you directly, and they agree not to solicit your employees or contractors to work for them. I mean, all this comes into the loyalty to the relationship. And there's a third type of non-compete under loyalty to the relationship that's not directly a non-compete, and that's what if the client or an employee comes to you unsolicited? It may not be a legal violation, but you may want to think hard about whether there's an ethical issue that someone who's been introduced to you solely because of this intermediary party is then being cut out of the relationship, and how will that middle party feel? You may want to insist that if the relationship started one way, that it continue that way, or at least get permission of the middle party before you start working with them directly. Last but not least is jurisdiction. This will really come down to who has the bargaining power. There are two basic places to litigate. That's where one party is located or the other party is located. It might be inconvenient to do it in the other place. You ideally get your own state or own location, but that's not usually something that's worth walking away from the agreement over a jurisdiction clause. International can be a little different. Arbitration is in a lot of these agreements. Arbitration has pros and cons. It's confidential, it's quicker, it's generally lower cost than full-blown litigation. As cons, it's not appealable, and there's no jury. So you have one person often making the decision, and if you don't like what their decision is, you're stuck with it. So you have to be aware of that if you're going into an arbitration. One practical effect is because it is lower cost, it tends to level the playing field, and that a smaller party can get into arbitration more easily and therefore more easily have a dispute with a bigger party, where that smaller party might be dissuaded merely due to the cost of litigation if the formal litigation was the alternative. And then finally, when you get the contract all put together, you want to get it signed. I still like a signature pen and ink on at least a scanned version of the agreement. But under Electronic Communications Acts, etc., any mark indicating agreement can be sufficient to accept a contract and make it a binding contract. That can be the X you see in the movies, or it can be an email signature, or a typed signature, or even an email that just says, I accept. So all of those are appropriate ways to accept the contract. But you do want to make sure that you have in your records that it has been formally accepted. And I think I'm at my last question and answer slide, and hopefully we have at least a little bit of time for questions.
Well, we're going to go and extend 3-4 minutes, and anybody that needs to drop off, this again is being recorded. You're obviously a member, so you get to take advantage of that. Charlie, why don't you go and throw up your last slide there so people can get your contact information or see that last statement. I have 4 questions here for you, and we're going to make them kind of shorter yes/no ones.
Sure.
One of them is a great observation. Clarifying, the first question is, on your slides in the lower right-hand corner, make your ideas untouchable. It's too small to see. Is that a copyright or a trademark next to it?
That is a circle R for registered trademark.
A registered trademark, okay.
That's actually our service mark for our firm.
Fantastic. And then there's this one, again, I'm trying to keep it a little bit summary short here, but this was covered a little bit, but to clarify, who writes the contract, the designer or the client? Does it need to be one of them, or can it be either one?
It often depends on who has the most bargaining leverage, because the person who drafts it has some opportunity to put in some subtleties there. So you get the battle of the forms. My preference is always for us to draft the contract, whoever we're representing, because then we can make some of those initial choices, and it's up to the other side to disagree if they want to change something. But a lot of customers will have standard contracts or a legal department that will insist on their contract. So that
you couldn't have set me up better for this statement, because I just discovered this actually as a Presentation Guild member. So anybody listening, there are right now 3 great legal templates on the Presentation Guild site. There is a consultant agreement template, a NDA template agreement, and a statement of work template. So there are 3 documents there. So if somebody is looking to write their own contract, or maybe just review what a contract from the designer perspective should have, these are really great documents. I actually was just reading them after a call with Echo when we were talking about this, and I didn't even know they were there. So there's a last thing. Last question for you, Charlie. You are based in Indiana. If someone listening is looking for legal assistance, 1, are you willing to talk to anybody? And 2, are you available for people outside of your state?
I'm happy to provide legal assistance certainly happy to talk to them, of course, anywhere. And then, yes, I have clients all over the country and all over the world. Now, if you're getting into a pure law question, we'll need to talk to a state attorney, but for a lot of my practice, it's federal law which can apply across the country.
Well, on behalf of the Presentation Guild, I'd like to thank you for your time. We have exceeded our time. There was just so much there. I think we could have come up with case studies and easily run another, doubled our time because of the number of questions that have come in. And just, it's a huge topic of interest, and it's on that whole business side of running a design firm that we don't always want to think about. So thank you for providing some great information, a basis of information for us to work from. And with that, we would like to say thank you and goodbye.
Well, thank you so much. And if anybody wants to send me questions, I can certainly answer those offline.
Fantastic. Thank you, Charlie. I really appreciate your time and letting us get some information from you. Okay, everybody. Goodbye now.